Good morning and welcome to this webinar, which is organised by the European Lawyers Foundation and the Council of Bars and Law Societies of Europe, the CCBE, on the impact of artificial intelligence on European lawyers' practices. My name is Jonathan Goldsmith, and I'm a Senior Project Counsel with the European Lawyers Foundation. We have a lot of people joining us this morning, and so while people are entering the webinar, I will make a number of important announcements as to how it will run. Number one is regarding questions. We encourage questions from participants, but please put them in the question and answer box, which you will find at the bottom of your screen, if possible, in English. Questions will be answered, if time allows, at the end of each session, or otherwise, if there's time, at the end of the webinar. Please don't use the chat for questions because they won't be answered. In the chat, you can say hello to us and tell us where you're from, but if you have questions, please put them, preferably in English, in the question and answer box. This webinar is being recorded, and the recording will be available on the website of the European Lawyers Foundation. The webinar will be held in English, but interpretation is provided into French and Spanish, and you'll be able to find the channel which suits you under the interpretation icon at the bottom of the screen. And lastly, two very important questions. We often receive many questions about the availability of the presentations you will see, the slides you will see. I have seen the presentations and they're packed with very useful information. Even if our speakers don't have the time to go through every detail, you will be able to consult the slides after the webinar on the Foundation's website. So it's the website of the European Lawyers Foundation. So don't ask us to send you the presentations. We don't do that. We put them on the website and you'll be able to consult them there. Secondly, a number of you may be looking for certificates for continuing legal education to prove that you have attended this webinar. We do not issue these certificates ourselves. What you need to do is you need to approach your bar, which issues the certificate. The bar will approach us to make sure that you connected to this webinar and for how long you connected. We will send that information to the bar. They will provide the certificate. So please don't ask us for the certificate. Now we will begin with the webinar. There's a slight change of program because the president of the CCB is unable to be here, but we have very good news because we have the first vice president of the CCBE who will become president of the CCBE as of the 1st of January of next year. And he is Thierry Vickers. Thierry chaired the Conférence des Bâtonniers in 2004-2005, and then the Conseil National des Barreaux from 2009 to 2011, which is the French National Bar. And he's also one of three authors of Règles et usages de la profession d'avocat, which is in France the reference book on the organization and deontology of the legal profession. Thierry, over to you for the introductory speech, please.
Merci Jonathan et bonjour à tous, bonjour à vous qui participez donc à ce webinaire en ligne. Comme Jonathan vous l'a indiqué, ce webinaire est le résultat d'une collaboration entre d'une part le CCBE, le Conseil des barreaux européens, et d'autre part la Fondation des avocats européens. Et il bénéficie également du soutien financier du programme Justice de l'Union européenne. Alors, pour ceux qui ne sont pas totalement familiers avec le CCBE, je voudrais simplement rappeler que le CCBE, c'est l'organisation représentative des barreaux de 46 pays européens. Cela veut dire que le CCBE représente plus d'1 million d'avocats européens par le biais des barreaux nationaux. Quant à la Fondation européenne des avocats, c'est un réseau de barreaux européens qui se consacre d'une part au développement et d'autre part à la mise en œuvre de projets comme celui-ci qui visent à renforcer les capacités de la profession d'avocat. Il arrive très fréquemment que le CCBE et la Fondation s'unissent dans le cadre de projets et d'événements, et c'est le cas notamment pour cette série de webinaires qui se concentrent sur des sujets qui sont particulièrement importants et pertinents pour les avocats. Aujourd'hui, nous allons donc traiter du sujet qui est probablement le plus urgent pour notre profession, celui de l'intelligence artificielle. Mais vous savez qu'il y a déjà pas mal d'événements qui ont eu lieu sur cette question de l'intelligence artificielle. Ce qui fait la particularité de notre webinaire, c'est qu'il est conçu uniquement par des avocats et qu'il est conçu pour des avocats avec pour objectif de s'interroger et de vous aider pour tout ce qui concerne l'utilisation pratique dans vos cabinets de l'intelligence artificielle. Nous avons trois temps dans ce webinaire, trois axes principaux. D'abord, nous avons l'honneur et le plaisir d'accueillir un représentant de la Commission européenne qui va nous donner un aperçu du cadre juridique de l'Union européenne en matière d'intelligence artificielle. Et vous savez déjà que l'Union européenne est leader sur cette question. Ensuite, eh bien, comme je vous l'indiquais, nous allons donner la parole à un certain nombre d'avocats, de praticiens du droit, qui vont vous présenter l'impact de l'intelligence artificielle sur la pratique quotidienne des avocats. Et puis, en tant que représentant du CCBE, en ce qui me concerne, je vous donnerai également un aperçu des principales questions éthiques que peut poser l'usage de l'intelligence artificielle. Voilà, j'en ai assez dit. J'espère que ce webinaire va répondre à vos attentes, qu'il va vous permettre de mieux appréhender l'intelligence artificielle. Et je vous souhaite donc une très bonne session, tout en remerciant bien sûr l'ensemble des intervenants qui ont bien voulu vous préparer ces présentations. Jonathan, je vous laisse la parole.
Thank you very much indeed, Thierry. And now we move on to the substance of the seminar, and the first session will be an introduction to the EU AI Act. Our speaker will be Laura Ugel, and again there's a slight change from the program, but Laura does the same work as our original speaker. Laura is a legal and policy officer at the European Commission, where she works in the European AI Office in the team responsible for AI regulation and compliance. Laura was closely involved in the preparation and negotiations of the EU AI Act, and in her current role, she works on coordinating and overseeing the implementation of the EU AI Act. She's a German fully qualified lawyer and has studied at the University of Mannheim and Sciences Po in Paris. So, Laura, over to you.
Thank you very much. Thank you for the introduction. I'm just going to put up my slides. Here we are. I hope you can see them well.
Yes, we can. Thank you.
Great. Thank you. Thank you for inviting me. I'm very pleased to have the opportunity to speak in front of all of you about the EU AI Act. Jonathan has already explained to you my role in the AI Act's development and negotiation, and now in the implementation. And I want to dive right in to give you a bit of an overview of what the AI Act entails. Maybe to start with, it's entered into force in August this year, on 1st of August, and the first rules will start to apply early next year. So we are at the beginning of this journey of putting the EU AI Act into practice. It's a very exciting journey. I know it will have implications on the work of many of you. And yeah, without further ado, let's get started. So I wanted to give you a bit of basics that I find are important to understand how the AI Act works. First of all, what is the objective? What is the aim of the AI Act? We developed the proposal a couple of years ago, and it came after the realization that while we want to encourage the use of AI in Europe, we want that more companies, more public administrations, more citizens can benefit from the advantages that AI can bring in terms of efficiency, in terms of improving work streams, there are also certain risks to safety, to fundamental rights. There's also a risk of incoherence in legal systems and approaches, and issues that relate to the enforcement of existing regulation that become aggravated when AI is involved. So what we wanted to put out is one coherent set of rules for the entire internal market, creating, in fact, an internal market for AI products, and meeting those concerns that can come with AI, ensuring that citizens, businesses, public administration can trust that the AI products on the EU market are safe and trustworthy. So the AI Act indeed has been designed to ensure trust in AI, in all AI that's developed, but also that is used in the European Union. And the regulatory approach that we have chosen is, and this is the first point which I find important to remember about the AI Act, the approach of a product safety regulation. What does this mean? We put in place rules for how AI products can be put on the European Union market, on the internal market. So what requirements do they need to meet before they can be sold in the European Union or put forward for download, as many AI products are software? That's the first thing. This means, on the one hand, that we don't regulate the technology, we regulate the AI systems, and to the extent they are products. And that also allows us to ensure complementarity, because AI is used more and more in all different kinds of products. It's not often a self-standing software solution, but many times it's integrated into machines, into toys, into online services. So by choosing a product safety regulation, we could ensure coherence with the existing product safety acquis when AI is integrated into products that are already regulated. So the AI Act, and this is my second point, has been designed to be complementary with other EU law. To give you a concrete example, robots, for example, they are regulated by the machinery regulation. Now, new rules that we introduce for AI that's integrated into these robots will be assessed in the context of existing procedures to ensure compliance with the machinery regulation. And the supervisory authorities that are responsible for machinery, they will also be supervisory authorities for the AI part. Third point, I mentioned it already, we focus on the AI system. This allows us to be technology neutral. We treat AI systems as products. They are defined in the AI Act. We have a definition, developing currently guidance to explain this definition well, to make sure that the scope is clear. And it allows also the AI Act to be a bit more future-proof. Our approach is to be innovation-friendly. One important point I have mentioned already is that we want to create an internal market. We want to ensure consistency in the regulatory approach all throughout 27 EU member states. But we also introduced certain tools in the AI Act to be particularly innovation-friendly. For example, we introduced the concept of AI regulatory sandboxes. In the future, all EU member states have to establish AI regulatory sandboxes where innovators can test AI solutions in a controlled environment, where there will be dialogue and regulatory learning also for the competent authorities involved. And then finally, and this ties in quite neatly, one part of being innovation friendly is to be risk-based. So while we have a horizontal regulation that applies across all sectors, we don't apply the rules of the AI Act to all AI systems in a similar way. In fact, we apply them commensurate to the possible level of risk that AI systems can pose. And this allows us to be very risk-based and proportionate in the approach. To go into more detail about what this risk-based approach means, the AI Act has 4 categories of risk exemplified by this pyramid that you may have already seen in the past. It's the graphic we always use to explain the AI Act, but it still remains valid and very good illustration of our approach. On the top, there are certain AI systems whose use can pose unacceptable risk to the fundamental rights and freedoms and safety and health in the European Union. That is, for example, social scoring. And these AI systems, or these AI practices more concretely, so the way these AI systems are used, will be prohibited. Then we have a category of AI practices that can pose high risk to the fundamental rights, safety, and health of EU citizens. And because they pose high risks, they have to meet certain requirements. We often say this is the core of the regulation. This is where most of the rules come in. I will talk about this high-risk classification much more, but a good example is in this area of recruitment, AIs that evaluate applications, because this is quite sensitive. It's important these high-risk applications do not have any inherent biases because they have not been well trained. They must meet certain requirements, but they are per se permitted. We have a third category that we often refer to as transparency risk. What we mean is there are certain applications where it's particularly important to be transparent about the fact that AI is involved in these applications to make sure that in the future humans can trust contents, can trust interactions. A very good example for that is impersonation, so chatbots that are very deceptively authentic and for which it may not be obvious that a human user is interacting with a machine and not with a real person. So in these cases, the human must be informed that this interaction is an interaction with an AI. Another field is synthetic content, so outputs of generative AI, deepfakes, for example. There are certain of these outputs where it's important that humans are informed that the output has been AI generated or AI manipulated, so that in the future general contents on the internet or in news and media can be trustworthy and we ensure a certain level of trust around the use of AI going forward. So there are certain disclosure obligations that the AI Act introduces for this particular risk category. And then, as you can see in the pyramid, also the biggest category are AI applications that bring about minimal or no risk. And for them, the AI Act does not introduce any new rules, so they are permitted without restriction. While, of course, certain other legislations may apply. For example, if the processing of personal data is involved, then the GDPR will still apply, but the AI Act doesn't introduce any new rules for these types of AI. To dive a bit deeper into each of these risk categories. So we start with the prohibitions. I will not go one by one, but I have listed here all of the prohibitions that the AI Act introduces. As you can see, it's not actually that many. It's very targeted. And these are really the extreme cases. The idea here is to draw red lines and to say these are AI applications and AI practices that contravene our EU values. The risk that they pose are unacceptable, so therefore they will be prohibited. You will see these are always practices, so it's not the AI system per se or the technology per se, it's a particular kind of use. You can see the second example from the bottom, emotion recognition. That's a very good example. Emotion recognition means that an AI system uses biometric data of a person to infer the possible emotions that a human has. And these kind of applications under the AI Act, you'll see in my next slide, they are in principle deemed high risk because they involve the processing of personal data, because it can be intrusive, and because if they are not properly trained, they can very easily have inherent biases. And in the workplace or in education institutions, their use is prohibited. So it's this particular practice that will be prohibited, not emotion recognition per se. And there is even an exception if they are used for medical or safety reasons. In the workplace, for example, sometimes emotion recognition is used to detect states of tiredness in workers who handle machines and to alert them that they should be taking a break. So these will remain to be permitted on the EU market. The prohibition is not absolute. It has some exceptions. Yeah, but I hope this example illustrated a little bit that these prohibitions are targeted only certain use cases, not the technology per se. The next category are AI systems that are deemed high risk. The high risk classification is built a bit on two pillars. On the one hand, as I mentioned already earlier, AI is integrated into a lot of already regulated products, which is one of the reasons why we have chosen to also design the AI Act as a product safety regulation. So certain AI applications, if they are embedded into these products, are deemed high risk. You see the conditions below. Either the AI system should be intended as a safety component or be itself the product. As a safety component means it has a function related to the physical integrity or the integrity of persons, the health and safety of them. The AI system itself being the product could, for example, be the case in the field of medical devices, where certain self-standing software tools are deemed medical devices, and if they are AI-based, they themselves would be an AI-based product. And in addition, under these other regulations, this is the second condition, the product must be subject to a third-party conformity assessment. If these conditions are met, an AI system that's embedded or itself one of these regulated products will be deemed high risk. This concerns 22 pieces of existing product safety regulation. I put some examples on the slides. You'll find them in an annex to the AI Act.
Laura, I'm going to interrupt you. Sorry, no problem
Okay.
with what you're saying at all. There is a black bar down the side of your slides. It's nothing to do with you. What I propose is that we show the slides at our end. It's come off, the black bar.
Yes.
Ah.
Apologies, I put in the little videos, but I have minimized them now, so hopefully you should be
Thank you. Perfect. Carry on, and I'm sorry to have interrupted you.
No problem at all. I've spoken about the one pillar, how AI systems can classify as high risk. The second approach is if they are used for high risk use cases. The AI Act identifies 8 areas that are very sensitive. For example, law enforcement, migration, the justice sector, and lists for each of these areas in an annex concrete use cases. And if an AI system is put on the market and intended to be used for one of these use cases, it will be deemed high risk. To give you an example, human resources is one of these areas. And within this area of human resources, there is one use case, which is AI systems that are used to evaluate applications. So for recruitment purposes. It's not any AI in the field of employment that will be deemed high risk, but only if used for this use case of evaluating applications for recruitment purposes. We also have a so-called filter in case AI systems fall under one of these use cases, but they really should not be high risk because they fulfill only narrow procedural tasks or other very limited functions. So then even AI systems falling under these high risk use cases can be excluded and deemed not high risk based on this exception. This is a bit how the risk classification functions, but the question is now, of course, what does it mean? Apologies, I'm going too fast. I wanted to highlight, because we are among lawyers, one particular use case of possible interest for you, which is the only use case in the legal sector. It is in the area of administration of justice, one of these 8 areas I've just mentioned. AI systems intended to be used by a judicial authority to assist in researching and interpreting the facts and the law, and in applying the law to a concrete set of facts. So in principle, doing everything that a judge would normally do themselves, or to be used in a similar way in alternative dispute resolution. So at the moment, in the field of administration of justice, not all AI will be deemed high risk, but only AI systems intended for this specific use case. There is more clarification in the recitals, and in particular related to alternative dispute resolution, because it's qualified that, in fact, in order to be used in a similar way, in accordance or within the meaning of this use case, the outcome of the alternative dispute resolutions must produce legal effects for the parties. So it's a limited field of possible alternative dispute resolution in which AI systems may be deemed high risk in the future. So I wanted to draw your attention to this point. I think it's quite important to emphasize. It becomes clear that at this stage, AI that is, for example, legal tech used by lawyers, that is used for limited tasks like handling of incoming claims and just smart document handling, AI-based document handling. All of this will not be deemed high risk under the AI Act and will not be met with additional new rules. And now we come to the part, what does it actually mean if an AI system is high risk? What are the requirements and the obligations? I think one part that is important to understand, and this also follows a bit from this product safety logic, is that most of the rules are on the provider. The regulatory burden is on those who develop AI systems and place them on the market. Why is that? It's a bit the approach to make sure that products on the EU market have already been tested. It's an ex-ante approach. Have already been in conformity with EU rules, so that an assessment has been done before they were placed on the market, so that anyone who buys them can trust that they are in conformity with EU law. And it's also logical because, of course, developers of the AI systems are closer to the system and can influence much more how it's designed, how it's developed, how safeguards have been built in. So the AI Act introduces requirements for AI system, technical requirements, with the objective to make them trustworthy and safe. These relate, for example, to data governance, human oversight, accuracy, robustness against cyber attacks. And all of these requirements will be operationalized through harmonized standards. These standards are in development, and the idea is that providers in the future, if they follow standards for the development of the AI system, can trust that the system is in conformity. They will have to carry out a conformity assessment. I've mentioned that. Depending on why the AI system classifies as high risk, this can either be done by the provider themselves or by a third party. And they have certain obligations that follow the entire life cycle. For example, they must do post-market monitoring, they must put in place quality and risk management throughout the lifecycle of the AI system. And finally, they have to register the system in an EU database that we are building up, in which all high-risk AI systems used in the EU in the future will be publicly available, with some exceptions if they are security relevant, used in the field of law enforcement. So providers carry the chunk of the burden, but deployers have certain obligations as well. First of all, they have to use the AI system, high-risk AI system, correctly. That's clear according to instructions of use that applies in all product legislation. They may have information obligations vis-a-vis affected persons. So if the high-risk AI system is used to make decisions about people, these people must be informed. And then there are certain obligations that apply to the public sector, that is to carry out a fundamental rights impact assessment, and certain others, but that's quite limited. And public sector also needs to register the deployment in the database I've just spoken about. So there is an increased level of fundamental rights related obligations and public accountability for the public sector when they deploy high-risk AI systems. Then I want to move on to the third risk category. These are the transparency risks. I've mentioned already a little bit earlier the two categories of rules that we introduced to ensure trust through this disclosure. On the one hand, disclosure is necessary when humans interact with an AI system. On the other hand, in relation to AI-generated content. For AI-generated content, what's important is that, and this is a common misperception, so I want to be very clear about this. In the future, any generative AI outputs, so images created by generative AI, text created by generative AI, they need to be marked in a machine-readable way. So they must introduce metadata or so-called watermarking that a machine can detect that the output has been AI generated. But we do not introduce that all AI generated output needs to be visibly labeled. There's a bit of a misconception. We only ask for these machine-readable marks. However, we do have some visible labeling, and that is for two very specific cases. First, for deepfakes, and then secondly, for text that is intended to inform the public on matters of public interest. These obligations related to AI-generated content, they tie in quite neatly with the regulation that we have in the field of platforms and information. And the intention really here is to facilitate also the fight against disinformation. For example, you may know under the Digital Services Act, providers of very large online platforms, they commonly, as a risk mitigation measure of systemic risks to democracy in the fight against disinformation, need to provide functionalities to allow the labeling of AI-generated content, and they need to themselves search for AI-generated content and keep it under control. And in the future, this will be much facilitated if all generated output needs to be marked in a machine-readable way, because then there can be certain tools that are integrated into an upload that already identify if content has been AI generated or manipulated. So this is a bit the intention here. I do not have an additional slide for the last of the pyramid, because as I said, there are no new rules regarding AI systems that pose minimal or no risk. But I have an additional slide that relates to powerful AI models. I have said in the beginning, the AI Act focuses only on AI systems and not on the underlying technology. This is the one example that we have. It's something that has been added during the negotiations, and it's more or less a reaction of the increasing proliferation of highly powerful AI models, often referred to as large language models, foundation models. The terminology of the AI Act is general purpose AI models. Why? Because they can be used for a wide range of tasks that they can very competently perform. And the AI Act also introduces rules for these AI models. These are the underlying technology, the components later used in systems. The reason for it is that to allow system developers to build safe and compliant systems, they must have all information to understand the capabilities of these AI models. And it was identified that model providers sometimes do not give this kind of transparency. So the AI Act introduces rules to ensure disclosure along the value chain, documentation of how a model is trained, and also of the content that goes into the training. There will also be these providers will also have to create a summary of content that they have used to train the model, which in the future will facilitate enforcement of copyright. So this is intended to help the existing, enforce better and implement better the existing copyright rules in the EU. But highly powerful among all of them, so models that meet a certain compute threshold and are even more capable, they must also meet additional risk mitigation rules. And because these rules were added during the negotiations, they are quite abstract. The idea here is to develop how they should be implemented in practice through a code of practice that is developed right now together with stakeholders, multi-stakeholders, AI developers, downstream industry, and also civil society and academia. So finally, I have spoken a lot about the rules. How will they be overseen? Who will enforce them? We have a bit of a two-layer approach. For AI systems, everything that's in the pyramid, because the AI Act takes a product safety regulation approach, we follow the existing approach that is done for other product rules, and we apply the market surveillance regulation. So EU member states will designate market surveillance authorities. They have a bit of time until summer next year, so this is an ongoing process. It will be quite complex because for AI systems that are deemed high risk because they are embedded into existing products, the existing supervisors will continue to be the supervisors, so good coordination will be needed on national level. But as I said, that's something which is very much under discussion and development right now in the member states. For general purpose AI models, so these highly powerful models about which I've just spoken, the large language models, the oversight is centralized at EU level. The idea here was that the developers of these kind of AI models are not many, very new field, new capabilities, new science and research. So it made sense to centralize capacity and oversight at EU level. And the Commission has created an AI office for this purpose. The AI office, I work at this AI office, it has more functions, but amongst others, it will be the regulator for general purpose AI models. We understand governance also a bit more comprehensively. So there are advisory groups integrating all kinds of interest groups. And these are the three you can see on the right-hand side. An AI board where the EU member states gather and coordinate the coherent application of the AI Act. A scientific panel that will support with technical advice, making sure that the AI Act remains up to date in all the decisions that we take to adapt it in the future, advising to make sure it's future-proof and valid, and always the state of the art. And then an advisory forum where a broader set of stakeholders will come together and gather and provide input for all decision-making going forward. So where do we stand with the AI Act? What are the next steps? At the beginning of my presentation, I have already mentioned that the AI Act has entered into force on 1st of August 2024. It will apply in a bit of a staged manner. We start with the prohibitions applying already early next year. The governance and the rules for general purpose AI models, these powerful AI models, will apply in August next year. So this is why the preparations are going on in the member states to designate the responsible authorities, and also on our side to grow the AI office and prepare for our role as enforcer of these new rules. The largest chunk, all other rules in principle apply in August 2026. So there is still a bit of transitional time. This is, for example, the rules related to high-risk AI system, the transparency rules. And there's one exception, the last category that has even more time, 3 years in total, which are these high-risk AI systems embedded in regulated products. There, the legislators wanted to give a bit more time because existing procedures must be adapted in order to integrate now this AI part well. So these rules start to apply in August 2027. What do we work on in the European Commission right now? So we're focusing right now with priorities on setting up the governance. We have set up the AI office. It's operational. We're building capacity, preparing for our role as enforcer. We are setting up the advisory bodies, which I've shown you. The AI board has already been established and has already met, will meet again still this year. The scientific panel and the advisory forum are in the process of being set up. We work very closely with the EU member states, support them, provide guidance to them as they establish the responsible authorities. We are preparing a lot of guidelines implementing in delegated acts to detail out how the AI Act should be understood, how it should be applied in practice. Our priority files right now are guidelines on the prohibited practices and on the AI system definition. In fact, I maybe can draw your attention to the fact that last week we have published and opened multi-stakeholder consultations to gather input for these 2 sets of guidelines. So I encourage you to have a look, provide input if you're working with AI and have relevant examples, or distribute this amongst your community. 2 other very important work streams relate to the same kind of objective to detail out how the AI Act should be put into practice. One is the preparation of standards for the high-risk requirements. I've already mentioned that the ambition is to have harmonized standards for these rules. These standards are under development by the European standardization organizations, CEN and CENELEC. In the AI office in the European Commission, we are following this process closely to make sure that in the end we have a good result that will provide a good tool to support companies and provides legal certainty. And then also something I have mentioned, we are working on this code of practice to detail out the rules for general purpose AI models. It's an ongoing process. In fact, last week we have published the first draft. It's an iterative drafting process. And right now the consultation is ongoing with these 1,000 stakeholders that are participating to the development. And hopefully we will have the final code ready in May next year.
Laura, I'm going to interrupt you because I know you're at the end anyway, and we have quite a number of very interesting questions. So wasting no more time, I'm going to launch into them. How do I know if I'm dealing with a single AI system or multiple AI systems when I'm dealing with a platform having multiple AI functions? Are these deemed one AI system, or is every functioning feature or part deemed an individual AI system which has its own risk classification?
So what is decisive is the final product as it is put on the market or integrated, put into service, we call it so used. So if you have, for example, a smart solution that fulfills 10 different functions, one of these functions is AI-based, the whole solution as such would be deemed an AI system. So to answer this very concretely, indeed, not each AI functionality, but the full thing is deemed the system.
Okay, thank you. Next question is, considering that ill-intended malicious AI usage will probably not comply with the AI Act, and its identification as AI is virtually impossible, is a label-oriented regulation not a bit naive?
If I understand the question well, it's a question that relates to how will we enforce.
Yes, I mean, in other words, label-oriented. If you've got labels about what is, what is not, when people are bad players, you know, is it not naive to expect the bad players to adopt labels and tell you what they are? I mean, it's they will just avoid them. I think it's saying, how will you catch the bad players?
This is where I spoke about the disclosure, where this other part of the marking of generative AI comes in. In the future, anyone who puts an AI system, develops a generative AI system, puts it on the market or allows its use in the European Union, has to make sure that the content is automatically marked in a machine-readable way. So even if someone tries to circumvent the labeling obligation for deepfake, the outputs would be detectable as AI. But indeed, it will be in the future important to ensure a comprehensive approach. I think it's not a single solution to have the AI Act. It's one part of the building block in the fight against disinformation. Working with the platforms regulation in this regard, working with media outlets is also important, and we continue to follow all streams and do not just rely on the AI Act, but we expect that it will help in the fight against disinformation.
Thank you, and thank you. I realize these questions take you off guard, so just answer it as well as you can. But the next question is related in a way to that. It's the same question in a way. It's specifically related to high-risk AI systems in law enforcement and threat prevention. And how can you ensure that these exemptions do not lead to systemic circumvention of protective mechanisms? The question says there are no independent control bodies, limited transparency obligations for security authorities. What specific mechanisms are envisaged to prevent misuse and ensure effective democratic control? Very big question, but maybe you can give it a stab.
It's a big question, and maybe to clarify for all those who wonder where this question comes from, the AI Act includes an exemption for national security. That is due to the fact that we have the EU competences as we have them. But law enforcement is not national security, so the rules for law enforcement will apply. We have foreseen quite a number of reporting obligations, particular for law enforcement. Certain uses of AI and uses of exceptions foreseen for law enforcement require even a legal basis, creation of a legal basis in the member states. So the Commission will monitor very closely how this is put into practice in the EU and work with the member states very closely on that and ensure that the national security exemption is not used as an excuse to circumvent the rules that the AI Act puts forward.
Thank you. Thank you very much indeed. There are more questions, but we've come to the end of the time. So if you're able to stay and keep an ear out, because we may, if there are no questions in other sessions, come back to some of these questions and ask you and the other speakers to answer them. So unfortunately, we need to move on. Thank you to all those people who've put those very interesting questions. And thank you very much, Laura, for your presentation. But we need to move on in the program. Thank you.
Unfortunately, I'm not able to stay for the Q&A later, but thank you very much for having me. And yes, I hope you spent an insightful rest of the day.
Thank you very much. Thank you once again, Laura, for your excellent presentation and answers to the questions. And we now move on to our next session, and this is the impact of the EU AI Act and other EU AI initiatives on lawyers' practices. So it directly follows from what we've just heard, but its impact on lawyers. The speaker is Lisha N'Alon. Lisha spent over 15 years as a commercial litigator and is now a non-practicing solicitor and vice chair of the Technology Committee of the Law Society of Ireland and a member of the IT Committee of the CCBE. She's a PhD researcher at the School of Computer Science at the University College Dublin, focusing on the governance and regulation of artificial intelligence, and her research has been published in academic and industry journals. So, Lisha, over to you, please.
Thank you very much. Thank you for the invitation to speak today, and thank you to the interpreters working today too. So jumping right in, this session will be examining the impact of the AI Act and some related EU initiatives on legal practices. And the real impact on legal practices as businesses rather than on the practice of law per se. So other sessions are, obviously the AI has a huge impact on our profession, and Thierry will be looking at ethics, practicalities of procuring AI systems from Peter, and generative AI from Marianne. And this session is more narrow, and I'm really thankful to Laura for that excellent presentation on the Act itself, which I hopefully will be building on. The potential use of AI in legal practices and the deployment of AI in certain use cases is at the intersection with all the risk cases that we're now familiar with, but it doesn't end there, and it's not just about the risk case. There's also an obligatory training element we find in the AI Act. And the provisions today that are relevant to us today link back to the foundations of the Act, so the foundations being safeguarding of fundamental rights, health and safety. But for us particularly, it's of interest is the fundamental rights. That's of interest to law firms as businesses, because that's really underpinning the relevant aspects today. So today, looking at a number of areas which Laura has spoken about before. So firstly, AI literacy. We'll be looking at some unacceptable risk cases, use cases which are relevant. Then high risk use cases or high fear that a lot of people have about that area, followed by transparency obligations, and then the product liability directives and some changes to those. So AI literacy, and the first thing to note, I think, on this is that it is a standalone provision. It applies to all deployers of AI systems, and that's regardless of risk. And critically, it's in effect from 2nd February 2025, so about 52 working days, not even taking holidays into account. So if we look at the recital, we can see the intention around this. So in effect, the reference to AI literacy is fundamental to the creation of norms around trustworthy and ethical AI. So the AI Act is a regulatory element of this governance. That's that hard law, but that's only one part of what's required in order to deliver effective AI governance. And this effective AI governance must also include soft governance in the form of norms. So based on recital, and it's recital 20, the intention of this aspect of the AI Act is to support norms for trustworthy AI, to encourage innovation, maintain competitiveness, and to assist organizations in complying with the Act. And so aside from the recitals, the article itself, Article 4, states that providers and deployers of AI systems shall take measures to ensure, to their best extent, a sufficient level of AI literacy of their staff and other persons dealing with the operation and use of AI systems on their behalf. Now, that you need to take into account their technical knowledge, experience, education, and training, and the context the AI systems are to be used in. You also need to consider the persons on whom the AI Act systems are being used. So that is quite broad on the one hand, but there is an expectation of a tailored effort. And obviously, training is going to form the basis of achieving AI literacy in your organization. But we need to bear in mind that it's not just applicable to organizations providing or deploying high-risk systems, but it applies simply to providers and deployers of AI systems. So therefore, any legal practice deploying an AI system, has this obligation in relation to AI literacy. So it's a broad net, but needs tailored effect. And it will depend on the technical knowledge, experience, education, and training. Then the extent to which it's tailored will depend on the tools that it's being used for. So depending on the firm, we could imagine the need for slightly different AI literacy programs, given the purposes to which AI is being put. Say legal professionals may be using it in quite a different way to HR or to finance, but whatever shape it takes, it must exist. And in the recitals, we also see reference to consultations with stakeholders by the Commission, member states, in drafting voluntary codes of conduct to advance AI literacy. So also in the recital 20, we see the kinds of things that would be covered, be measures to be applied during its use, suitable ways in which to interpret the output, and in the case of affected person, knowledge necessary to understand how the decision had an impact on them. So unsurprisingly, we expect training to form part of this initiative, but it's unlikely to be off-the-shelf training, given the need to tailor to that particular environment, and work will need to be done in advance to establish the context. Excuse me. So steps towards compliance with AI literacy requirement. You need to establish what AI systems are being deployed. And that's an audit sort of process, and indeed that needs to be carried out anyway, and many organizations have already started in that process. Then you'll need to assess and evaluate the existing level of AI literacy within the organization. And with any training program, the existing knowledge should be assessed. You could simply accept that there's quite a low level of knowledge, even if there's a high level of awareness, but that needs to be a decision needs to be taken on that. You need to design the appropriate training, and that'll depend on the role within the system, but some use considerations might be looking at compliance and ethical aspects, possible opportunities, risks, harms of AI systems. You'll also have technical considerations, may include good practices during deployment, or how AI outputs should be interpreted correctly, and identifying possibly mitigating risks associated with prohibited practices. Like any training program, mechanisms for monitoring and documenting compliance and measuring effectiveness will be important. But in this case, you'll also need training records to demonstrate compliance with the Act. And this is not just for legal professionals. You may be used to holding records for mandatory CPD schemes for lawyers, but this is going to be across the board in the organization. And then it's probably a case of rolling out training and then adapting it as the state of the use of AI in the practices and indeed regulatory requirements change, then the training will need to be updated for this cyclical training of staff. We should also bear in mind that this links in with the requirement to assign human oversight of AI systems, say in certain areas. So that human oversight, competence, training and authority, this may intersect with the AI literacy element. That is the literacy requirement. Now we're going to look at an unacceptable risk category, which may be applicable to legal practices. And one that stands out is emotion recognition in the workplace, as referred to by Laura. So you can see there's our pyramid triangle. So that unacceptable risk. And emotion recognition, if we look to recital 40, it states that it refers to emotions or intentions such as happiness, sadness, anger, surprise, disgust, embarrassment, excitement, shame, satisfaction. And this is based on biometric data. So the article itself, placing on the market to infer the emotions of a natural person in the areas of the workplace, also education institutions. So what biometric data are we talking about? So text can be text image capture, gait analysis, or posture analysis. And you might think, we'd never use emotion recognition in our practice, but there are instances which might seem anodyne, in which emotion recognition might creep in. So you could be running training on presentation skills. Trainers often use video analysis. That analysis can often use AI for emotion analysis. How stressed does the person seem? Now, for the avoidance of doubt, I'm not suggesting that emotion recognition software is effective, just merely pointing out that these products are sold. But in other areas, you could see e-learning environments will often adjust the content based on the inferred emotional states of the learner. In recruiting, tools used to assess candidates' attitudes, emotional states through analysis of expressions, body language, voice intonations and modulations. These are being used. Some firms monitor emails, so sentiment analysis from the text could find its way in there. Many firms use external providers of wellness programs, and so data-driven wellness programs may fall foul of this prohibition. Some employees have smartwatches from their firms along with their work phones. Does the firm have access to this data? Was there a spike in heart rate? Are you a bit angry? So this element can creep in, and it's something to be cognizant of. You might ask, but why this use and why there? You know, why emotion recognition? Why has that been called out, and why in the workplace? And again, it's interesting to look at the recitals on this point. And recital 44 notes that there are serious concerns about the scientific basis of AI systems aiming to identify or infer emotions. Now, stepping outside of the recital, this statement reflects the scientific community's lack of consensus on the efficacy of emotion recognition. Back into the recital, they say, particularly as expression of emotions vary considerably across cultures, situations, and even within a single individual. It says that there are shortcomings, including limited reliability, lack of specificity, limited generalizability, which therefore can lead to discriminatory outcomes, and they can be intrusive to rights and freedoms of concerned persons. So then we say, well, you know, why the workplace specifically? Why is that referred to? And it goes on, workplace, that there's an imbalance of power in context of work and indeed education, as that is also covered under this. It refers to the intrusive nature of these systems. It says it could lead to detrimental or unfavorable treatment of certain natural persons or whole groups. So you might say, well, if emotion recognition is so unreliable, so potentially so detrimental, why is it not deemed unacceptable across the board? And I think that's probably a debate for another day. But for the moment, it's this prohibition on inferring emotions in the workplace. So So we've looked at that unacceptable risk in law firms, emotion recognition. We've looked at AI literacy, and we're going to move on to situations in which high risk category will apply to the business of a law practice. It's an area which I think does instill fear in people when they realize they might fall within one of these categories. So Laura's spoken about that, the harmonization regulations, those safety components element. What we're interested in appears in Annex 3 of the Act, and specifically employee management, so worker management. When it comes to Article 6, as Laura set out, if it doesn't pose a significant risk to fundamental rights, including by not materially influencing the decision, if it's a simple, narrow procedural task, if it's improving previously completed human decision, if it's detection of decision-making patterns or preparatory task for broader assessments, then it may be not deemed to be a significant risk. But notwithstanding the potential for providers to deem systems being used in HR as not being high risk, I mean, you could say that would be a little bit of a risky approach to take, given how difficult it would be for an employer to argue that the use of the AI system in the HR cycle doesn't impact on fundamental rights. And in any event, employers would need to be cognizant of their obligations in any event. But it all remains to be seen how this is going to pan out. But let's look at more detail in more detail at these provisions. So what's of note, I think, is that the provisions in relation to worker management, it covers the entire HR life cycle, even before recruitment has occurred, all the way through to termination. So again, this is the high risk under Article 6. So AI systems intended for recruitment or selection, so it's even attracting candidates. So examples are given of targeted job advertisements. So if they're being shown to only particular groups of people, tools to analyze and filter job applications, which are very, very common, and then tools to evaluate candidates. The element of progression and performance in the HR cycle is also falls within Annex 3. So AI systems intended to make decisions affecting the terms of work-related relationships, promotion, allocation of tasks, monitoring and evaluation of performance and behavior. And then finally, AI systems intended to be used to make decisions regarding termination of employment. So that is the full cradle to grave of the HR life cycle. So if the organization is deploying high-risk AI system, what are the obligations? Referencing back to Laura's points there, there's a transparency element. The organization must inform individuals that it intends to use high-risk system in the decision-making process relating to that individual. So prospective candidates must be informed if CV filtering is being used. In employment context, the organization must also inform worker representatives and impacted workers if they will be subject to AI decision-making or assisted decision-making. Maybe data protection impact assessment. Deployer may need to use information provided by the provider to carry out that DPIA. And then in some cases, a fundamental rights impact assessment. So this is for public bodies and private entities carrying out public services, and then also for a certain financial services domain. The human oversight we referred to earlier must be assigned to a person with the necessary competence, training, and authority. And this is where the positive obligations with the AI literacy requirement overlaps. And then if the deployer controls the input data, which is likely, then the data must be appropriate for the end goal. So it must be relevant and sufficiently representative. In addition, under Article 86, there's a right to an explanation. So if a decision has been reached in a high-risk Annex 3 use case, aside from critical infrastructure questions, but a high-risk case then which produces legal effects or similarly significant effects or similarly significantly affects that person, and they believe that it has adversely impacted on their health, safety, or fundamental rights, then they have the right to obtain meaningful explanations of the role of the AI system in the decision-making procedure.
Can you slow down a bit? The interpreters ask. Sorry, Alicia, to interrupt you.
Apologies.
But we're very close to the end. In a minute, I want to ask you some of the questions. So if you could wind up and then we can come to the questions. Thank you.
Okay. Moving on, so that's the employee. I guess we'll just move on to the other AI initiatives, which may be relevant, which is the product liability. And the product liability, which establishes a strict liability framework for damage, that's been updated to include software and, by extension, AI systems and products that incorporate AI technology. And then we have the proposed AI liability directive, the idea to introduce rules for non-contractual fault-based liability. This is still being negotiated, and there was an impact assessment study from the European Parliamentary Research Service. It was issued on the 19th of September 2024. There was talk of extending the scope of the AI liability directive to include general purpose and other high impact systems, suggestion of a mixed liability framework for fault-based and strict liability, and then a recommendation to transition from AI focused directive to software liability regulation. And perhaps I'll pause at that point.
Thank you. Thank you so much. I'm going to begin with a question. It's a political question, which was put to the last speaker, but I'll put it, she probably wouldn't be able to answer it, from Konstantinos Terzis, who says, do you think that we're overcomplicating matters in comparison with our commercial competitors, the USA and China? In other words, our EU companies are going to be over-regulated compared to companies from other territories, and we will suffer as a result.
So as we know, our values, the protection of fundamental rights, health and safety is so important to us in this jurisdiction. I think that in some ways the idea that regulation necessarily dampens innovation isn't a black or white situation. It depends on what we value. Will we see that consumers are valuing products from this safe and protective environment? So these are questions. I think we also need to ask questions about the deployment of AI resources. I know that people would like AI to solve all of our problems, but we should be deploying AI resources to problems which can be solved by AI, as opposed to problems we would like to solve by AI. And so I think it's not a black and white question. I guess
good answer. And I'm going to put two questions to you, which are they're around the same topic which you mentioned, emotional analysis and using AI to analyze. So one person asks, is emotional analysis allowed for border control or law enforcement? Is there scientific data about the robustness of such analysis? That's one very big question. And the second very big question is, we already use body language to understand the general disposition of those we communicate with. If appropriate safeguards are in place, why should reading body language via AI be inherently forbidden? So maybe you could just elaborate on those.
I might just take the second one first.
Sure.
So, the idea that I think it comes back to an extent of what we're applying AI to. And it is one thing to apply AI to the physical world, and I'm talking about things that we know where there's a ground truth. So you can tell the computer, say for example, this is a tumor. We can identify that is the case, and it's something different to apply it to something in our human world, which doesn't necessarily have the ground truth. You may look at me and you may see me, you don't know me, you may think that I'm very happy, smiling here. You may not know that I'm a bit nervous about giving a presentation. So we don't have absolutes on that. And it's not unlike, I think, applying AI to general, and I guess to an extent, the ideas of emotions are social constructs to an extent, like we have named these emotions, but say applying it to social constructs like law. So we don't have a ground truth in that. Law has been created by people for people. So I don't think that we can necessarily apply maths, because effectively that's what you're doing, apply maths to something like emotions and how somebody is feeling, when sometimes people themselves don't know how they're necessarily feeling. In relation to, sorry.
Go on, yes, I was going to say, please just deal with border control in 1 minute and we must move on. Thank you.
So yes, the biometric, that is a different category, and I'm not going to profess to be an expert in what is happening in terms of law enforcement and biometric control.
No.
Less
Okay. That's fine. No, indeed. No problem with that whatsoever. Thank you. Thank you so much for your full answers. There are other questions, but we don't have time for them. So it just remains for me to say thank you very much indeed, Leisha, for your excellent presentation and answering of the questions. Thank you. And we will move on in our program now. And we come to the next topic, which is the ethical use of AI by lawyers. And the speaker is somebody we've already seen, Thierry Vickers, who's first vice president of the CCBE. Thierry, and just to add that when Thierry is finished at 11:35, we will have a 10-minute coffee break, just so that you know that in advance. Thierry, over to you.
Thank you. Thank you, Jonathan. Can you see my screen?
We can. We can hear you and see your screen. Thank you.
Great. So I am wondering, why are we so many people this morning to follow this webinar? And I think the answer is obvious. It is because within months, every lawyer will be using artificial intelligence tool. AI is spreading quite quickly in the profession. Let's see those figures, which came from a recent report. They are from US lawyers, but I think everything will happen exactly the same in Europe within some months. In 2023, when you were asking to lawyers, do you use AI tools and do you intend to use them? It was quite clear. There was a very small minority of lawyers who are currently using artificial intelligence, and a majority, 60% of lawyers, was replying, we don't intend to use that kind of AI tool. And within months, now in 2024, when you ask the same question, everything had changed. We have already 34% of lawyers who use AI tools, and you have also 56% of lawyers who are decided to use AI tool, which means that within some months, I think that 100% lawyers will be using AI tools. And when you try to compare the speed of adoption of AI tool to other technology as cloud, you can see that we are moving faster, really faster than ever in adopting that new technology. So I think my first prediction is that 100 lawyers will use very, very soon those tools. And what kind of tools? What kind of tools? You have an idea of what is going on with those figures. It means that many lawyers, and even a majority of lawyers, will use more than one AI tool, and more than that many tools will be not designed specifically for lawyers. I mean that you will use in your practice AI tool from lay people, ChatGPT, Perplexity, that kind of tools will be used in our practice. It is something which is also very new, because until now, lawyers were using for research, for e-discovery, really specific tools. It will be not the case for AI. AI is offering to everybody, to every practice, a kind of tool that can be afforded by every lawyer in Europe and everywhere. So this is one of the elements you have to take in consideration. Every lawyer will use AI tools, and it will not be necessary tools that has been designed for lawyers. Now, try to see what happened with the clients. Things are also going very quickly in that field, since already a majority of clients is waiting for lawyers to use AI tools. It has been done in a very short time, but now our clients are waiting for the use of AI tools. And I think the second prediction we can do to this morning is that 100% of clients will ask their lawyer to use AI tools. And if you check, you check the client and compare the position, the situation by age of clients, you can see that the more clients are young, the younger the clients are, and the more they are decide to ask for the use of artificial intelligence. So 100% clients asking to 100% lawyers to use artificial intelligence. Are there risks? Probably yes. And I think you have already heard about those cases which has rise in every jurisdiction. And I have some example to show you on the screen of lawyers that have been that have problems with using artificial intelligence, with the case in USA, but also in Brazil, in Argentina, everywhere, the same kind of case, in fact. Lawyers who rely on the result of AI tool without supervising that kind of result. You have already many of those cases pending, and the list is growing every day. So that's true that there is an ethical problem with the use of artificial intelligence. And to try to understand the kind of problem you can make, I think you have to go to the scenario of use in the practice of lawyers. I have tried on this matrix to present you 4 scenarios of use. They are depending of the competency of the lawyer, who can be a beginner or who can be an expert. And it depends also on the capacity of the AI tool. That can be a very basic AI tool, or that can be an expert AI tool. And let's try to check what's going on when you create a couple with a human being, a lawyer, and with an AI tool. First, if you give a basic tool to a young lawyer, to beginning lawyers, you will get some improvement in the quality of the work, but it will be a very limited quality improvement. Now, if you gave to the same lawyer an expert system, the couple will be more effective than the lawyer or the artificial intelligence alone. But you will get a huge supervision problem, since the human being will not be able to supervise the result of the artificial intelligence tool. So it's obviously one situation that you must avoid in a law practice. Then, if you give a basic tool to an expert lawyers, you will be disappointed, because you will create a kind of dependence for the lawyers, and the result will be of a very limited quality. It means that an expert, a human expert, lawyers, don't have to use a basic tool because it will not improve at all the performance and the quality of the legal work. And finally, the best scenario is obviously to give a very good AI tool to a very good lawyer. In that case, the couple is really more effective than the lawyer alone or than the AI tool alone. And obviously, in that case, you don't have anymore a supervision problem, and you can improve speed and result in the legal field. So when you see that matrix, you also realize in what kind of situation you will get ethical problems and in what kind of situation you will not get ethical problems. Beginning in 2020, and CCBE was leading in that field, national bar has begun to wonder about the ethical consequences of the use of AI tool. We have seen many initiatives in Europe, and I have tried to summarize those initiatives on that slide. And as you can see, many national bars are doing the same work at the same time, because obviously the problems are the same for any lawyer without any dependence on the nationality. Same in USA. In USA, it's the New York bar which has been the first to give recommendation as in 2020. But you have only the California State Bar, you have also the Florida State Bar, and also Pennsylvania Bar Association. And finally, in 2024, the American Bar Association, in the formal opinion 512, has given those recommendations on the ethical use of generative AI by lawyers. So, more or less, it's the same thing on each side of the Atlantic Ocean, with a lot of initiative to give guidance to lawyers on the use of AI. If I can try to summarize what kind of initiative has been taken by bar. Sorry. You have three methods that has been used by national bar to cope with the question of the ethical use of AI. First, try only to interpret the rule as they exist now. Second, try to adapt existing rules. And finally, you have some bar which decide to create new rules for artificial intelligence. And obviously, you can have a mix of those three initiatives, and you have some bar who have decided to create new rules, but also to adapt or to interpret the existing rules. To go into details, what has been created about new rules? In fact, the first thing, and it has always been said by the previous speaker, lawyers have the obligation to understand the tools they are using in their practice. They must also be enabled to supervise the result which has been produced by the AI. They must also be transparent with their clients, giving information about the use of that kind of tools. And I have to say that I think that that kind of obligation will no longer survive, since every client will be asking for the use of AI tool and will not asking for information, but for use of AI tools. Obviously, you have also rules about supervisions. And finally, you come back to the formation obligation. So when you check as new rules that has been created by BARS, they can be summarized with 3 words: supervision, formation, information. Now, going to the adaptation of rules, which are the rules that lawyers must adapt? The first one, obviously, is about confidentiality. The second one is about competence, the question of supervision, the question of billing, and finally, the question of communication. In the confidentiality field, we know that kind of tools can create problems for clients' data. Lawyers will have to rely on AI tools that are able to protect client data. And if they are not able to protect client data, they will have to obtain from their client consent before using confidential information into an AI tool. After that, going to competencies, we've seen that some bar are adapting their rule to extend technological competence to the appropriate use of AI tools. Also, in supervision field, we see that some bar are creating or adapting the existing rule to establish clear policy on the use of artificial intelligence within the firm, which means that lawyers will have to write that kind of policies on the use of AI within their own firm. Obviously, you can find also there some rules about the formation of lawyers, but also formation of the staff of the practice on the way to use AI tools in an ethical way. If I go now to billing, you can imagine that we will have to adapt our billing practice for the AI tools. I think it will be obvious that you cannot bill for the time saved through AI, which means that clients will have to benefit from the fact that lawyers are now able to realize the same legal works in a very, very short time. And finally, you will have some obligation of transparency about the use of AI tool by your firms. Finally, some bar have only decided to interpret the existing rules and have considered that you can reply to the ethical questions only by interpreting the existing rules. And we begin with the duty of diligence, which exists in many ethical rules, and it's only about applying the duty of diligence to the verification of the results that has been given by the AI tool. With the rule of professional independence, you can ask to a lawyer to maintain that professional independence, in fact, of AI result. The integrity rules is able to allow the bar to ask a lawyer to verify the accuracy of the result that has been provided by AI tool before submission to the court. And you have seen that all the examples of breach of ethical rules have been related to the use of information given by AI tools before submission to the court. And I think that every lawyers who have already used that kind of tool have been able to realize that in the field of giving reference, legal reference and legal case reference, AI tool is quite able to very frequently hallucinate, which means creating, inventing legal case, legal precedent that does not exist. Obviously, the duty of integrity is asking for lawyer to verify the result before submitting them to a court. The rules about professional responsibility are also able to cope with some of the ethical problems we made, since it's obvious that the lawyers will remain responsible for any work it has been produced, even if it has been produced by an AI tool. Lawyers will stay responsible, and the rule on professional responsibility will be used as they are in that field. And finally, obviously, we will have to cope with the current rules on the question of conflict of interest, because as I have tried to explain you, we will use the same tools. And if 36% of lawyers are already using tools like ChatGPT, it means that there will be potential conflict of interest that will be generated by the use of chair AI tools. In that field also, we will have to cope with the rules, the ethical rules that are.
Thank you.
At this time.
Sorry,
Yes, Jonathan.
I thought you were finished, Thierry. I know this is your final point in the final slide. Sorry, are you finished? Because there are a couple of questions I'd like to ask.
Yeah, sure.
Thank you. Thank you so much. Thank you for your timing too. First, there's both a comment and a question from Dace L. Lutters Tummel. The comment is, some companies advertise now by showing an advantage of being able to ensure trustful and ethical AI. That's the comment. The question is, what kind of AI literacy is expected from lawyers? And the questioner says there's a difference between being literate in an AI tool and literate in AI, and prompts that prove the prompt that you give in your questions, that AI literacy is producing better results and enables us to judge outputs better than only AI tool literacy. So I don't know whether you've any comments on those points.
I completely agree with the fact that you cannot ask to a lawyer to be a specialist in AI technology, but you can ask him to be able to understand the tool he is using. And what do means trying to understand the tools you are using? I think it means being able to stay in the field of your own competency. I mean that it's very tempting for lawyers to accept a case in which he is not competent, since he knows that he will be able to rely on AI tool. I think it's really, from an ethical point of view, one of the problems that will be made for lawyers. There is really a temptation to get out of the field of its own competency. I think you have to be technically and also ethically competent to use that tools.
Perfect, thank you. And the last question I'll ask before we must break for our coffee break, and I ask it specially because the questioner did not put this question in the question and answers box. Please put the questions in the question and answers box. I only happened to come across this, and it ties into your point, Thierry, about hallucinations, and how can professionals effectively detect and manage AI hallucinations in their work? What is their ethical responsibility to track down hallucinations? We know that some lawyers in the US got badly caught out by this and elsewhere. Please.
I think it's come back to the question you have asked about the competency of lawyers. You have to be able to prompt and to prompt correctly, which means to be able to ask to the AI tool the questions that will allow you to supervise and to check the result. For example, if you ask for case law, ask in your prompt to the AI to give you a link to the text of the case law. And doing that, you will be able to go to the source, to come back to the source and to check if the source is the right one or not. And I can say by experience now that in 90% of the case, it's not the case. It's not true. It's false case, or meaning the AI has not understood the case, or maybe he has given you a link to a case which is not related to the question you were asking him. So I think everything began with the capacity to prompt correctly, to learn to use that kind of tool, because they can give you very, very good and very impressive answers, but they can give you very, very false answers because I will not try to humanize them, but they have an answer for everything.
Thank you. We need to end. I need to apologize to Dace. I was very conscious that Dace might be a man or a woman, and I tried to refer to her as the questioner. I must have slipped in unconsciously a he when I was referring to Dace's question. Dace is a she. I apologize, Dace. I really do apologize for that. I was very conscious that it might be, and in fact, she's just writing that she's a former vice chair of the German Women Lawyers Organization. I'm sorry. Thank you, Dace, for clarifying all of that. Thank you, Thierry. Thank you very much for your excellent presentation and answers to the question. We've come to the coffee break. There are other excellent questions out there. Please, questioners whose questions have not been answered, please, they're remaining, and if time will come, we'll ask them. They're excellent. We'll now break for let me just check that I get the right, I think it's for 10 minutes, I am sure. So we'll now break for 10 minutes, yes, coffee break, and so we'll start again at 11:46. Thank you. Please don't go away. We'll start again at 11:46. I see it's exactly 11:46 now, so we will begin again and welcome back from our short coffee break. We now move on to a session which is called The Challenge Facing Non-English Speaking Countries Regarding Generative AI. And we have two speakers from two different non-English speaking member states, from Denmark and France, to talk about the challenges that they're facing. First up will be Marleen Winter-Plaas. Marleen is a partner at DLA Piper Denmark and is head of intellectual property and technology in the Nordic countries. Marleen is a tech lawyer and advises both Danish and international companies, as well as public authorities in this area. Marleen assists clients with the negotiation and drafting of complex technology and data protection agreements, AI, and cybersecurity. I'll introduce our second speaker now as well, so there won't be a break between them. After her will come Alexandre Corratella. Alexandre is a member of the French National Bar, the Conseil National des Barreaux, and in particular is a member of its AI steering committee. Alexandre is admitted to the Paris Bar and practices corporate and business law. So with that, Marleen, you're our first speaker in this session. Over to you.
Thank you very much for your nice introduction. I will share my presentation. So here we go. Is it okay?
It is perfect. Thank you.
Perfect. So yes, I'm first of all going to talk about the challenges from a Danish point of view that we are facing as non-English speaking country regarding especially generative AI. In Denmark, we speak Danish, and we have a kind of a civil law system. And the problem when we talk about generative AI, we talk about the use of the large language models, as we have talked about before in this webinar. But the LLMs, they're trained primarily on English data and data from common law countries. So it's also, we know, yes, they have, because the internet has been scraped by ChatGPT, by Copilot, etc. So of course there are in these models also Danish, German, French, Swedish, Norwegian, whatever data in these models. But we cannot, because the amount of data is so small, the amount of Danish data is so small, that we cannot use it for that reason, because of the language, but also because these, for the legal documents, they have been trained on common law, primarily on common law documents. So we cannot use them for our everyday work in our professional use. But so we have to do something different. But the problem is that we need so many data. We need a huge amount to train a national model. And that's not only for us in Denmark, it's for every time you have to train a new model, AI model, large language model, you need trillions of tokens or data points, so before you can get a decent model. But we have nevertheless in Denmark chosen to develop a national model. And the challenge was taken up by in Denmark, IBM Denmark. It was the Danish industry, Dansk Erhverv, and Alexander Institute. And the Alexander Institute is an institute under, I would say, University of Aarhus, and they have like two legs. They do have a commercial leg, but they also have a leg where they actually, together with Danish foundation models, they develop large language models. So early this year, they launched the idea, I would say, to create this DSK, Danish Large Language Model Consortium. It was initiative. It was a private initiative, and which is very good and has become very popular. We have worked the last couple of years, I would say, since now it's 2 years coming up for ChatGPT, and there has been initiatives on a public model in Denmark. It's not like we're not going to work on a public model, but these entities, these companies, they took the initiative to start this private model, inviting the public sector into it. When they first started up, they had drafted a letter of intent, which was not drafted by a lawyer. So I contacted them and said, do you want me to assist you on drafting some legal documents for this setup, this consortium? So I got involved from the very beginning in this very, very interesting work. So Alexander Institute has been making a lot. All three entities have been making a lot of advertisement for this Danish model. They have or are still collaborating with Sweden and Norway, and also now there's going to be a European model. They have been talking to a lot of different companies, entities, public, private, and it has become a success, I would say, but we are not there yet, because we need really, as I mentioned before, we need many, I would say, trillions of tokens or data to have something very solid. The idea of this model is that all participants they provide data. They provide so good data for our law firm. For instance, it could be an outdated website. It could be outdated marketing material. It can be everything that is in fact already public. So when I'm saying this, it's also because I'm saying that we have to limit the amount of personal data, of course, to put into this model, not to create any data breaches. So that is very important. So when you are actually providing or you're sharing data with this consortium, you have to make sure that your data is good and there's a limited amount of personal data. You cannot say without any personal data, because that's not possible, but it should limit it to the maximum extent. Then the data should not infringe any copyright. And that's a big issue, you know that, and we have already talked about it a little bit this morning as well, that there's in these large language models, there are infringements of, for instance, copyrights, trade secrets, etc. So as the data owner, you have to make sure that the data that you're providing is not infringing any copyrights. And then you have to make sure, of course, that it doesn't have necessarily to be up to date. So it could, as I said before, be like an outdated website or marketing material. It could also be templates for various legal documents. But it's up to you yourself as a member of this consortium to bring in this data. The starting point for this data, for this consortium and for this Danish model was something we called the HorseNet. And the HorseNet was dated back from the 1990s. And it was a place where people, they could chat about information about horses, but it became a place where you can actually exchange good information about whatever issues came up in your everyday life, cleaning, how to clean a carpet in certain situations. So, but the thing about this HorseNet, and it's quite funny, is that people they talk very nicely to one another. So it has been a good starting point. The idea is that we create based on Munin. There's going to be, I'm not saying we because I'm not a part of the development phase, but that this Danish foundation model, working closely together with Alexander Institute, they will create a model based on Munin, or called Munin. It's based on one of the existing large language models. And then you will say, but is that a good idea to have something that exists because it's not adapted to Denmark? But the idea is that is the start engine, but it's going to be replaced by this Danish engine in the end. And then it's going to be made available as an open source. So everybody can actually use it after it has been developed. And that is the idea, that it should not be only for members, but it should also be for other entities who want to use this Danish model and develop based on that their own model. It could be for DLA Piper Denmark, but it could also be for all law firms in Denmark that we make a common model for all the legal information that we need in our everyday life. So the idea is that everybody can use it. These are just some of the members that I just wanted to show you, to see that it's a big mix of public entities, but it's also private companies, and it's big and small, and some are in the financial sector, some are already AI companies, meaning that they're selling AI products. It's also the Association of Accountants and lawyers. So of course, what is the goal here is that we get the big data, the public entities that have a very big amount of data, like the Royal Library, etc., on board on this, so we can get a Danish model that has enough data that it makes it's a good and viable model. So this is the very brief, small presentation of the Danish model, the Danish large language model. It will not. I would just finish by saying that it would not be a competitor to ChatGPT, or it will not be replacing ChatGPT or Copilot. It will be a model that would live, I hope, hopefully side by side with the other language models, because the fact that we cannot use Copilot or ChatGPT for our legal work, we can use it for so many other things, and being careful, as some of the other speakers have said.
Thank you so much, Marlene, for keeping to the time. And there are already a couple of questions coming in. So we move now to Alexandre, who I would ask to show his slides, and then we hope we will have time at the end to ask a couple of questions. Alexandre, over to you.
Thanks, Jonathan. I'm here to speak about France perspective, because we face the same challenges as non-speaking English, non-English speaking countries, because we have an amount of data in the scale of a country, but it's nothing compared to data which has fed the LLM model. In France, we are a country of continental law, which is very important on two sides. One side, we have French law to be ruled and to be used in French since l'édit de Villers-Cotterêts, but we have an issue regarding our structure of law. As a continental law country, we rule on codified text, codified law, and we use the cases law and the precedents as a tool, and it's not binding for us. So the logic behind the core, the body of law, it's quite different from common law, and it will be the first issue for us to use ChatGPT, for example, as a main tool for legal work. Basically, we represent for the government which has issued their statistic, we represent only 0.2% of the data used to train LLM. We have a system with open data for cases, corporate information, law, something like that, but it's only few information in the global perspective. So we need to train our model in French with the logic of the civil law and continental law. And for that, EU as a project, which is called in French, but I don't have the translation. There is the reference on my slide, Altedic, which European initiative who gathers 16 members, including Denmark, including France, and many of the countries who are not ruling in English. The project is actually led by France and is declined countries by countries. In France, we have this structure. This is the state-owned project led by the Ministry of Culture and the Ministry of Tax, basically, of budget. There is a team who is actually recruited, and we have two committees. One on the cultural bias to avoid any hallucination on this perspective, and one on the legal and ethic issue regarding professional secrecy, but I'm not here to discuss this particular topic. And Altedic in France is actually working on long AI, which are the LLM who will be trained by French data and trained in French perspective, which are actually propulsed by National Archive, National Library, and National Institute for Scientific Research. So we have many actors with the datas and relevant datas, and we have a coordination by the Direction Numérique for basically the digital affairs, which is an initiative of many ministries, and it's quite interesting. It's quite interesting because DINUM, the Direction du Numérique, is actually leading many projects to step ahead in digital in France. So they have, in my opinion, they have the big picture of the digital, and it will be interesting as we can use some tools like that to improve the corporate initiative for the legal work, improve the major actors of AI in France, like Mistral, and it should be useful for us as a lawyer or for the judge, because the Chancellerie, which is a Ministry of Justice, has already tell us that judges will use AI in their work, and there is some ethical issue and some practical issue to have lawyers and judges on the same basis of work for using AI and long AI will be a tool for that. We have already some corporate initiative, mainly by the major actor of publishing in France, as LexisNexis or Lefebvre Dalloz, which are a major publisher of law book. They use mainly ChatGPT or Perplexity to work on their datas and have fewer hallucination as they close the work of the AI on their datas only. By using RAG, they are actually able to deliver some answers and some content on legal work, which is quite relevant. We are actually at the CNB auditioning all AI companies operating in France to have a big picture of which is disponible, which is available in the area of legal work and the area of support for the lawyers. And in the few words, we already issued guidelines for AI use, ethical and practical, and we will certainly issue more guidelines to on use case, for example. It's okay for me.
Very good. Thank you very much indeed, Alexandre. And these slides will all be put on our website, and you'll be able to look in detail. Obviously, there's a lot of technical information from our speakers, not only Alexandre and Marlene, but others. They will all be put on our website. You can see them all there. There is actually a few comments from Dace, who's asked questions before. One specifically to you, Alexandre. She asks, this pan-European initiative led by France, is it only a Francophone project or does it include other languages?
It is European project, and if my comprehension is right, there is one pan-European initiative, and the project is declining in every countries to work on that initiative. So I think they will be able to work in many languages.
Very good. Thank you. Yes, there. Peter Homeke has answered one of the questions asked. Well, I'll read out Peter Homeke's answer. Thank you, Peter, because Dace also said that DeepL was trained with the proven European, in other words, the official European official journal, and would that be an option to train a European LLM in the legal sphere? I'm happy for both Marlene and Alexandra to comment on this because it was addressed to the two of you. Peter said, yes, it is possible, and there are other options as well, including a wider body of law or cases. However, it's not enough to train an LLM from scratch. All the EU case law and public law would be far too small of a corpus body of text for that. That links back to what Marlene said about how many trillion, I forget what the figure was, of information is needed. But this amount of information can and should be used for different methods of fine-tuning the large language models. So I don't know whether Marlene or Alexandra, you want to comment on that as well.
Yeah, I totally. It was about the DeepL, right? Using the data, the data from DeepL. It's a very good idea as long as they have an open model and they have a licensed model, and the one that we're using here, for instance, in GLA Piper, is the licensed one because it's more easy to use it because you can actually insert personal data and you can insert some confidential information. But for sure, there's the one that you can have for free trial or whatever. You can. I totally agree. It's a good way to go. And there is of course, a certain amount of Danish data in DeepL again. It's a very small amount. So, but thank you for that, and I totally agree.
Alexandra, anything? There's another more general question, which it doesn't just cover the very specific thing you raised, but it does in a way. What are the plans of the EU to educate lawyers in the different countries how to use AI tools and large language models ethically and according to the AI Act rules? Maybe I can answer just very quickly that I know that the EU takes this very seriously, and that large funds will be put into what they call digitalization of legal services in the coming years. But I mean, it's a very interesting point about the specific Danish and French language models. I don't know whether either of you have thought about how you will train your local lawyers. Either you want to speak?
Alexander, do you want to go first?
Yeah, okay. At the CNB, French National Bar, we are actually thinking about training of the lawyers, because we have two challenges. One is to train any lawyers to use AI, because it will be a massive event, a massive plus on the practicing. And we have another challenges, which is to be able to have any lawyers in France who is actually able to understand the ethical challenges. It will be by training our students, as we have a system with trainee and the school for the bar, and it will be on this stage for the trainee in the French school bar. And we have also training for lawyers, which will be organized by the school, the bar school, to and the French National Bar to implement some reflexes on this topic, ethical and practical. And it will be a major challenge for us to be able to have a product which is democratic, and which is adopted by the one person law firm and the major law firm.
Thank you, Alexander. Marlene.
Yeah, I think it's so interesting, and I think I'm going to take that one up, Alexander, to have this kind of education as well as a part of I mean, the education before being admitted to the bar. So I think that's a very good idea. We don't have that in the Nordic countries, but what we suggest when we talk about it, because I'm a part of the AI work in the Association of Danish Lawyers, Danske Advokater, and what we actually, we say to everybody is that you should make it mandatory for people who, before using these AI tools, especially the large language model, that should receive at least 4 hours of training. Because I totally agree that the training is a very, very important part of using the tools, knowing how to use it from a practical point of view, but also all the ethical issues that we do have, as we talked about earlier in this webinar. So I totally agree.
Thank you very much. Thank you very much, both of you, Marlene and Alexander, for that. I ask you to stay on, and I'm now, before I come to our next session, I'm addressing all the speakers because there are really quite a lot of questions which are outstanding because we've kept to the time, but there is time at the end to deal with questions which have not yet been answered. So I'd ask all the speakers to look at the questions and get ready with answers, and then we'll pick some. There are too many to answer them all, whichever one you feel comfortable answering, and we'll go back to them and answer those questions when we finished with our final session. And the final session now is a checklist on the acquisition and development of AI tools. Our speaker is Peter Homaki, who is a lawyer from the Hungarian Bar Association. He's a former chair of the CCBE's IT Law Committee, and he continues to be a member of it. And he's the author of the CCBE's guide on the use of artificial intelligence-based tools by lawyers and law firms in the EU. So, Peter, welcome, and over to you.
Thank you very much. Please, can you hear me well?
Yes, yes.
Okay,
Perfect,
thank you.
perfect.
Okay, so hello everyone, and thank you for the introduction as well, Jonathan. Well, I would like to give you a presentation today about what is benchmarking and what lawyers should think about when they would like to use some of these tools. I will talk about, focusing on what's the lawyer's most important issues, a checklist when buying AI-based tools, especially on how to measure and compare the performance of these tools. That's why we are talking about benchmarking as well. I will give you a broad overview of how these tools fit among the legal tech tools and where we have to pay special attention to the use of such tools. I will not discuss the price of such tools. Why it's important, the legal tech market in the EU is so very fragmented that it would be very difficult to say anything meaningful about that. There are as many available tools as countries, all with different pricing. So, following a short overview of the major security issues, I will introduce you to how lawyers can start to trust these very complex and highly diverse, but often really unreliable tools. What is a data set? What are the benchmarks about, and how did they change with time? I will try to introduce you to some of the more exciting current research on the reliability of these AI tools. And I try to close my presentation with a summary of the major pain points with benchmarks, why there is no really good solution to the reliability of AI tools in law in general. On the left, you can see that there are many different layers of commercial legal tech tools. These all rely on legal databases of some sort, which is at the bottom, but it could mean also public data, like published cases and laws, and also private data, which is owned by the publishers or customers. When we talk about AI tools, we have to differentiate these new tools on the top from the more traditional legal tech tools. And from our point of view, the main difference is not about the technology, what kind of technology they use. It's more about how predictable they work, because they are complex in a different way than traditional tools. And the problem is that they will not always come up with the same results, and that's why they can surprise the users. So we have this serious special risk with these tools that you cannot really manage by training the users the same way as you train them with the traditional tools. You have to show them, some of the surprising results, why they have to be extra cautious. So there are very important technological differences in the background as well, but this unpredictability is the focus point for us. We will be discussing the layers highlighted on the left, machine learning and large language model-based tools. These large language model-based tools are also called as generative AI tools. And there are also some previously harmless categories of tools that lawyers were using, which now incorporate such new functionalities, which make these tools even unreliable to a certain degree. So AI is a marketing label, but the tools will not necessarily have the big title on them saying that they are AI-based tools. On the right, you can see some software that is often incorporates AI capabilities. Those are marked with red background. These are quite generic tools that can, some of those include AI-based tools, the practice management, contract management, but others will not necessarily use that. They could be, older tools. But for those with the blue background, you should presume that this machine-generated output will need some human-level review, unless you have information to the contrary. Let's take a more in-depth look. So blue tools could come up with incorrect results or even very different results than the last time you used it. and for tools using a certain technology, there is also a remote chance of some of your data being leaked to third parties. That's why we have to be cautious with using ChatGPT as one of the questions. But we'll return to this later. But practice management and case management tools, based on what the publisher wants to market, they can include different functionalities. Some include functionalities like analytical functions, which use large language models, but some not. Some use it for drafting, some will not. But if these tools include such functionality, you have to give the results the same level of human review as you would give it to a dedicated AI tool with a blue background. So that's why you have to be aware of the weak points of the tool you have, no matter what kind of tool you are using. And even if that doesn't mean you have to become machine learning specialist, but you have to be aware of these weak points. So for software supporting legal drafting, you can create very complex drafts, even with traditional technology, which was cutting edge like 50 years ago. But this kind of problem is very different of what you can see when you are using large language models. So especially with large language models, if you give an instruction, also called the prompt, and the prompt you give is not specific enough. We do not give the necessary details for a clause that we would like the tool to draft, and we expect the tool to fill out this gap by common sense provisions, like what we would expect from a trainee or a human trainee. Information retrieval tools, also called sometimes research tools, they are also not new for legal practice, but the larger amount of information we have, the more mission critical their functionality becomes. And the less we can do about any decrease in the performance of such research tools. Depending on the task and the use case, sometimes it is a bigger problem if the tool gives you too many false results. But sometimes it's a bigger problem if they miss a single but still important instance. It depends on the use case. And of course, if these information retrieval and extraction tools are unreliable, then it's no surprise that any tools relying on such functionality, like analytical tools, will be at least as unreliable. And this lack of reliability could be caused by unidentified problems in the examples that the model was trained on, or even in using the model for some new real-world problems that it was not really prepared to handle. The last line, I'm mentioning chatbots. Chatbots could mean different problems for lawyers. And what we have to know is that there are those kind of chatbots that restrict the valid set of questions and answers to a set of templates. And the risk here is minimal. But chatbots that simply plug into large language models and are theoretically restricted only by the instructions, the prompts we give, they can easily step out of their guardrails, and therefore they can mean catastrophe even for a law firm. In relation to the security of AI tools, the biggest risk is losing access to your own data. While many AI tools rely on some form of cloud computing services, it is usually not easy to export and back up all the information you have in the tool in the cloud, including any work in progress, because there are no standardized AI tool applications. There is no standardized format of how these kind of tools store and process your data. So when you have to find a new provider for some reasons, it will be very difficult, if at all possible, to transfer the data to your premises or to a new provider. And of course, vendors come and go. They merge into larger providers. They cease their business in less profitable markets. And this could all result in your loss of important data. Similarly, most AI tools rely on some form of cloud computing services, at least during the analysis, but often during some storage of your data as well. And it is your responsibility to make good use of the access control tools that these tools provide you, no matter how inconvenient they are. You have to learn how to use these access control tools. But beside the traditional problems, you have to, as I've mentioned, it's very important to understand what the vendor is offering and what kind of tools they are using. Where can they introduce this new kind of surprises, where you have to focus extra human attention on the results. So be also mindful of where the vendor is located, how responsive their customer service is if you need some help. Now I would like to turn to the performance of these AI tools. considering that these AI tools are quite unpredictable by nature, we have to better understand just how unpredictable they are and for what kind of tasks. To rely on the capabilities of these tools, we need to introduce some level of how unpredictable is this unpredictability. And this can also help us reduce the fog, which is sometimes created by the publishers who want to sell us their tools more. And they provide sometimes misleading information. The vendor is providing misleading information. So by relying on appropriate benchmarks that are published or by vendors or measured by third parties, we could in theory compare their relative performance and the value of these tools. Benchmarks are used in machine learning and AI in general to evaluate or measure certain characteristics of the tools. This could be a measure of the performance, as in our case, we will be talking about this one, but there are also different benchmarks for more specific purposes, like measuring what the toxicity is of a tool or a data set, how fair the results are, these are different benchmarks. But the point is that benchmarks give us results that we can compare. And to have a benchmark, you will also need a standardized set of data, both regarding the input, what kind of examples we train our tool on, and what are the expected answers, the golden set. Benchmarks and data sets are specific to a specific task or a role or a domain. It's not enough if you have like one data set for the English language and translate it. That's not really how it works. And that's especially true for law, as well as the previous presenters have gone into some details with regard to this. So there are also benchmarks that are composite of different results in several data sets. So there are benchmarks of other benchmarks. There are a collection of other benchmarks. I would like to give you some examples of these benchmarks and see how they differ from task to task. The first one is about natural language processing task. This is the more ancient benchmark that are still useful in the legal field. They were created first to show how these tools can perform in terms of language-related questions. This first example shows you question, answer, source triad, where the extract provided is used as a basis for answering a number of closed book questions, like here about the Bible. There is this benchmark squad, which means both a data set and a benchmark, but part of that data set is used for training, and another part of this data set was used for evaluating the performance of the tools. You can see in the right bottom corner a leaderboard, which shows you the results. You can compare even the human baseline with the results from two models back in 2021. You can see that these models from 3 years ago already surpassed human baseline. Of course, this doesn't mean that humans became superficial, but it just means that this is a very specialized task where current tools can perform better given certain preconditions. But another traditional NLP task is summarization. Here, the machine-generated summary is compared to a predefined reference summary. The article, and there is the summary in the example. And the performance of the tool is measured to this kind of standard summary answer. Similarly to Squad, this rogue performance was also once a widely used benchmark. And the third example is classification, which is, in this case, classification is based on how well the tool can perform tasks that would require, if done by a human, some kind of understanding the text. This will, of course, not mean that the AI tools understand the text in the same way as humans do, but it is still a good measure, and we can still use it to compare the performance of the tools. Of course, if we see the improving results, this also gives us some remote hope that the tools which excel in this benchmark, this is called a super glue here, will also approximate human understanding in some ways in the future. This super glue is a composite benchmark this is made of 10 different tasks. And I have highlighted 2 called binary classification tasks, which seem quite easy, very artificial examples. They are not really close to what humans would do. The decision of the 2 has to be made based on the passage, the extract of the text here. And we can see, what's the question and what should be the correct answer. Now I'm turning over to the legal task benchmarks. And the first examples are very simple. COLI is a question answering benchmark. The tool is evaluated on 5 different tasks. One of the tasks is about what is the correct article in the Japanese Civil Code as a response to one of the 806 specific questions that they have decided, the researchers have selected. The second one, mode, is a data set for testing how well the tools can perform in correctly choosing the right answer for a specific contractual clause in relation to merger agreements. So this is a very specialized tool for a very specialized legal task. Similarly to this one, QUAD is another data set. This is used to compare how the tools can answer questions related to specific provisions of commercial contracts. Like, is this text that you see here, is this a governing law clause, or is it not a governing law clause? The last one on this page, LexClue, is a superset of different data sets. One of these data sets is made of sentences from 50 online terms of services. And the tool is evaluated by trying to give the correct answer. Is this provision from an online contract considered an unfair term under EU consumer law? And if so, identify which of the 8 possible categories this provision will fall into. So just to give you an understanding how to create these benchmarks, of course, it's a lot of effort. So you need some kind of legal work behind to have a data set which can be used as benchmarking, while some simple data sets can be outsourced to be done by legal students or law students. The others will need more expensive expertise like the merger agreements understanding. Compared to the earlier machine learning tools, the latest large language models like GPT-3 and later, or Gemini or Llama, they have special capabilities that warranted the creation of new specialized evaluations for them. So they are not using Rogue or Superglue. That's why the examples that you have seen were like 3 years ago from the AI tools were from 3 years ago. And in the legal domain, we can also find both new benchmarks and the reuse of previous data sets for these LLM tools. One such most famous benchmark was the GPT-4 test, where the model successfully passed the unified bar exam. You can see 2 examples here. One example is a multiple choice answer for the multi-state bar exam, which lawyers are using in the US in many states to decide whether they can qualify as a lawyer or not. And the other, which is about writing a short essay for the multi-state essay examination. And of course, it's only the highest performing large language models that are capable of generating relevant, extensive text that meet the quality standards here. So while this was a very interesting paper about GPT-4 passing the bar exam, and it gained enormous visibility, it's not really something that is really helpful for your lawyers, because we are not working by passing bar exams daily and answering multiple choice questions. That's a bit different how lawyers work. That's where these new generation of legal LLM benchmarks are useful. We have a legal bench is a more comprehensive superset of almost all the existing previously shown simple legal benchmarks. And it's called now, the paper that I published about this legal bench, they said it's about measuring the legal reasoning capability. But of course, despite the title, we have to highlight that there is no guarantee that these tools performing well on the legal bench benchmark will have any legal reasoning capability at all, and not in the way that we lawyers and other humans use this. But for us, it's more interesting to see also that there are lots of new evaluations which were created for non-English speaking languages and non-English law sources like in Arabic or Greek. And we can also see an increasing number of studies that were done just to evaluate how reliable these large language models are in general, how strong their capability to hallucinate is, and how much that hallucination can be further reduced by special techniques like feeding, making it accessible for all the legal case law and all the legal databases we have, or just crafting by hand which is called chains of prompts. So one prompt, after one prompt, before giving us the answer, the draft answer goes back to the tool and that evaluated again. So we can also see that large law firms have been publishing their results of what the experience was with these large tools, these large language models. It's very important for them because these these tools that are specially created for law firms are very, very expensive. And as you can see, the results of the hallucination results, even for these specialized tools, it's pretty bad. So it doesn't mean that the tools are not useful, not important. That's far from being true. But it does show that we have to be wary of the results because it's a normal feature of these tools to give you hallucinated answer, no matter how much money you spend on these tools. So we must remain aware of the limitations and risk, and to understand how to mitigate these risks. We have to review the output, no matter how well these are integrated into complex chain and complex AI workflow. So benchmarks are very useful tools to make our life easier and to help us with the spread of AI tools, but there are also some generic problems that we have to be aware of. One, of course, that these tools, they cost quite a lot of money, and you cannot really generalize well on these tools. Just because you have a data set and an excellent benchmark in the English language will not mean really anything for your own language, which is not English, if you're not using the larger jurisdictions. And the other next problem is that the benchmarks should be, of course, made accessible to a lot of people, because then we know about the benchmarks. But that's also a problem because vendors, they will try to over-optimize their tools on the published benchmarks, which is called also like contamination or a train test leakage. So they train the data, their large language models, on the available benchmark results, and that's this way the tools can excel and can bring much better, show you much better results than in practice how they will operate. That's a big problem, and it's not like car companies that have this kind of trying to do the shortcuts. It's true for every vendor, even AI tools as well. It's not about carbon dioxide, but it still can skew the market and skew which tools are really better than the others. And also it's different how you use these tools for lay people. If you like to use evaluate how these legal large language models are used by lay people who are not trained lawyers, they have a very different use case, and they want the reliability is very different from how we professional lawyers use these tools. So we would probably need different benchmarks for these different categories. And the last and the biggest problem is perhaps that there is not really a correlation necessary in the expected performance, because how they work is different. Just because we have a very good results in an understanding type of benchmark or a reasoning benchmark, this will not necessarily mean that the results in live use will be as good as that one. We still have to expect surprising failures in tools with good benchmarks. Thank you for your attention.
No, thank you, Peter, for your presentation. And I say to those who were listening again that the slides will be put on the European Lawyers Foundation website, and also Peter has an accompanying text, because obviously some of what he was talking about, there were a lot of technical references. There's an accompanying text which will also be put on the website. There's a question here for you, Peter, and then I'm going to throw open the questions to everybody, which from Dace, which is the CCBE thinking of giving guidelines on which AI tools well, are allowed, probably not, but should be allowed to be used in legal practice?
Well, I think the problem is that the possible scope of AI tools is very, very wide. So CCBE is carrying out a serious work in relation, to the principles or the guidance, what kind of tools should be used and what are the risks. But there are so many AI tools and so fast changes in this field, it would be really impossible to enumerate these kind of tools that you can access and tools that you can use. I think it's so it cannot be as simple as, okay, this tool has like the approval of CCBE or the approval of the national bar. That's difficult to have, in a general approach. But what you can have is to show you examples, like what you should have to be aware of, what kind of surprises you can find. Like, let me give you an example, DeepL. We have discussed DeepL already. If you are aware that it happens that if you feed like a 20 pages long document to DeepL, which gives you the English translation, but unfortunately it happens to change Hungarian forints into euros. So the sums remain the same, but the currency is changed. We don't really know why this happens, but this is a serious problem, and especially if you feed it long documents, that you have to be aware of this very, very critical risk.
Very interesting reply. Mirto Soufli asked a general question as you were talking. Thierry has given a very witty reply. I'd like you and then any of the other speakers to add in. So Mirto says, well, finally, will AI replace the legal profession? Thierry said, it will replace those lawyers who don't use AI. But I don't know, Peter, if you begin off, whether you think that AI is going to replace lawyers.
No, definitely. You have to go down, to the actual use of these tools to see that it really depends on the AI tool that you're using, what kind of technology they are based on. But actually, the current generation of these tools is so unreliable and can give you so surprises that even with insurance, it's not going to work. So it's not like placing. Because nobody will insure these kind of tools as they currently stand. If and when these tools should ever reach, the artificial general intelligence level, which kind of it's more like a science fiction still to this day, and then yes, of course, they could replace the human profession, the legal profession as well as other human professions. But I don't see any signs today which indicate that would be feasible in any future.
I'm going to have a follow-up with you, but I do encourage Thierry, Marlene, Leisha, and Alexandra, if they have any comments on this or the further questions I'm going to ask, please to come in. But I mean, I have read very recently that these research that the large language models have reached a kind of a level, a plateau, and no matter how much information they're pouring into it, it doesn't improve in terms of accuracy or the general intelligence that you're talking about. And so, I mean, I don't know whether you have any comments on that, and therefore whether there ever will be some kind of great leap forward to equivalent to human intelligence.
I wish I'd know, but yeah, currently, yeah, I agree. It's not something that you can see coming. And because, if you had asked me the same question, like in 2023, May, we wouldn't have known, everybody was just still awed by the excellent results given by GPT-4. And everybody was talking about, okay, in 1 year's time, you see there is, so much things will be possible, and still so many time has passed since 2023 March And we still have not, the tools became better, of course, and in many levels they are more advanced, but there is no like network effect here. There is no like explosion of capabilities going beyond humans.
No, now I think, Thierry, you're answering this question, but actually I'm going to ask you to answer it in person to everybody. I'll ask it to Peter first, then Thierry, but I again repeat, the other speakers can come in, which is Catherine Hoon says, I understand that all AI tools hallucinate, even those which are specifically designed for lawyers. Is this correct?
I would say all large language models hallucinate, because that's, there are some AI tools which can give you, the definition of AI is very wide, as you can see, like in the AI Act. It's not really, there is no good definition. So there are tools which can provide you with reliable answers, but most of the tools that we consider as AI tools, including those relying on large language models, they do hallucinate. And the problem is that these benchmarks have shown, these research papers have shown that even if they improve the tools, they giving the data, legal databases and all the case law, the performance is improved, but it still hallucinates to such a degree that you cannot say it's hallucination free, or hallucination has become so irrelevant that we don't have to focus on it.
Yeah, okay. And Thierry, I don't know whether you have anything to add to that, or Marlene?
No, I just wanted, I totally agree with you, Peter. What I wanted to mention is that we have to be careful when we're using any of these tools for our legal work. I mean, I experienced with one of these translations models that we have talked about before, the DeepL, that if it doesn't understand a sentence or it doesn't understand a chapter in your document, it just doesn't translate it, So it's not, that was one thing I wanted to say. The other one is, do you think, Peter, that that these models are going to work differently after they have to fulfill the transparency requirements in the AI Act? Because because I don't see how these, OpenAI and Microsoft will be able to fulfill these requirements. So that was a question back to you. Sorry.
Yeah, I think what we can, so the more information we have regarding transparency, the more difficult it will be for companies to remain ahead of the competition. So, it's even nowadays, what these extra tools that are trained on legal databases, they're not really that special. So I'm not saying that anyone could create similar tool, because the databases that they are trained on are proprietary. So they are not like necessarily accessible to everyone. That's especially true for common law. But so I think transparency is really helpful, because it can show us, what's the smoke and mirror, and what's the real performance of these tools that we have and we can access. But yeah, and it will also be very, very difficult for these current leading firms to ensure that they comply with copyright. That will be very difficult for them.
Leisha, you wanted to speak.
Thank you. Just on the point of legal tech, so say some of the products where they say that they are, trained on legal text only, or that they're confined in some way. These are generally based on the larger language models. So it's a little bit like saying somebody's going to university and they're studying history or politics. It's not to say that they forgot how to read from when they were in their junior school. So to say that these models are, very confined on legal texts isn't correct, because effectively they learned to read on all of the rubbish which went into the LLMs. So just be wary of organizations stalling the virtues of their legal products on that point.
Yeah, Thierry, I have invoked your name many times. Please speak.
Yes, I think that hallucinations are simply a statistical feature. So it's not a bug, it's a feature of the system. But I think it will not change the fact that there will be broadly used, because the system we use now, the research motors, engines that we use since the last 20 years, has exactly the same problem. exactly the same statistical difficulties because they were doing the same mistake. So I think we have to be obviously very careful, but it will not change the fact that everybody will go and use it very, very broadly.
Thank you. This is a question for Marlene, I think. I don't want to put anybody on the spot, and if anybody knows the answer to it, please speak. It came a long time ago from Catherine Rapp saying, how do you think that copyright law will change in the future in relation to AI? I don't know whether she means because of so much material being stolen by LLMs to feed them, but I don't know whether anybody wants to answer. Marlene, I know you do this, I think you do this area of law. That's why I start with you.
I think we in Europe have the in our national legislation we have this opt-out model that we have to be very careful about using when we have a copyright, and that is something that was written before this directive was written before the rush of ChatGPT. So we have to be aware on how to use it and to make it available so that the big models also respect it. So there has to be a very clear communication on that, because that is, I see that is the way to get your, if you publish what they will do, your copyright on the internet, that is the way that you can get protection from today. That is what they have, what we have today.
Anybody else want to contribute to the answer there? No. Then let me see some of the other questions which were asked. I mean, Thierry, actually, maybe you can answer the one which you did answer, which was asked earlier, which was, is it safe to upload documents containing client data to ChatGPT or any of these large language models, or should we remove personal information beforehand? Maybe you could speak to the whole audience about your answer.
Yes, thank you, Jonathan. I think you must absolutely avoid to do that if you use any tools, any free tools, because there is no protection at all about data. But if you use, if you pay for your system, you have only to check the condition and the rule that can be very different from one model to another about confidentiality. But I'm sure that many of the actors of the market are aware of the sensibility of the question of data, which means that many of them, as long as you pay for the service, are giving some protection. Obviously, you still must be aware. But on a practical point of view, I am afraid that I'm pretty sure that it's so complicated for lawyers to anonymize, for example, documents, that there will be used probably sometimes without many precautions.
Yeah, I understand. If anybody wants to add, please do. I'm going to put two questions to, yes, Leisha, please say something.
Thank you. Just on that point, that even if the terms and conditions provide that it is confidential, there is obviously always the potential for a data breach or data leakage. So obviously then it still falls back to the lawyer to defend themselves in the event that that wasn't appropriate. I'm not sure about relying completely on the terms and conditions of certain organizations, which may ultimately not be as safe as we might hope they would be.
Yeah, understood. I think these will be the last two questions. I'll put them together. They're both asking the same thing, which is disclosure of use of AI, and that's why I'm putting them together. So shouldn't lawyers, I wasn't sure whether the question was lawyers or lawyers and judges, but lawyers anyway, tasked with drafting judgments or documents which are being used, be made to declare whether they've made use of AI tools and whether they've verified the information they would have obtained by using these tools? That's one disclosure question. And the other one said, should machine translations in a product, for example, example, the compliance tool, terms and conditions, cookie banner, privacy policy, be disclosed as part of the product? So I don't know if anybody's able to answer this, but who would like to go first?
I will go for the judgment. I think it's obviously one of the things that the legal profession must ask, asking for the judge to explain what part of the judgment, if any, has been created by an artificial intelligence and which tool has been used. I think it's something that we must ask for the system.
Right. And anybody want to add to that in terms of disclosure of use of AI? Yes, Peter.
Thank you. Yeah, I would like to just highlight that this rule can be very general. So this could be understood that if you have used like an AI or a large language model in any way during your output, just tell us how you did that. I'm not sure it's really the lawyer's job to give these kind of results, and I'm not sure that it would really help the client. On the other hand, because lawyers, are usually just responsible for whatever they send to the court, to the client, and but there are certain cases where it's necessary. It's certain use cases where it would be like an important information. If you're providing like a chat kind of legal services, if that's possible in your jurisdiction, I think that would be a fair request of the clients. They're just to tell us, is it a lawyer who is providing the answer, or is it some kind of different under the law firm's name, or is it just some kind of tool? That's important, more like not to mislead the general public. But I'm not sure that like in court briefs, that's an important information, because I have to remain responsible for my full brief, no matter what I've used. And I'm not sure that, giving them the fine examples of what drafts I did, how many trainees I've involved, how do I review it, I will still be responsible for the results same way.
Understood. Thank you, everybody. We really are coming to the end of our time now. And there are excellent questions which remain. I apologize to those participants whose questions haven't been answered. Very good questions. We've just run out of time. I think it's important to finish on time. I would like, first of all, to say thank you on behalf of all our participants, very much indeed, and give a token round of applause from myself for all our excellent speakers with the excellent slides. I repeat that the slides will be put on the website of the European Lawyers Foundation, where you'll be able to read them. It's also just to mention that we will be running another webinar under the same program, the same EU-funded program that has funded this one, on the 2nd of December, about preliminary reference procedures before the European Court of Justice. And if that topic also interests you, please register for that. So it remains for me just to say thank you very much to all our speakers. Thank you very much to all our participants. Thank you for your active questions. And we look forward to seeing you all once again somewhere else. So that we bring this webinar to a close. Thank you very much, everybody, and goodbye.